Hi friends, today we are going to discuss about mental capacity under Mental Health Care Act of 2017. Myself, Dr. Suresh Badadmat, Professor of Psychiatry, Head of Telemedicine Center, Head of Forensic Psychiatry Unit at NIMANS, Bangalore. Before I start my presentation, I would like to have a disclaimer. The disclaimer is basically whatever we are going to present in this presentation is for academic and awareness purpose only. This is not a substitute for legal opinion. For legal opinion, please do contact an advocate. Conflict of interest? None. Today's presentation will be revolving around the mental capacity assessment. This mental capacity assessment has been dictated by the Section 81 of the Mental Health Care Act of 2017. So what does Section 81 says? Section 81 clearly says that Central Mental Health Authority will form a committee to form a guidance document. The committee was consisted of the chairperson, Professor B.N. Gangadhar, the director of NIMANS, Dr. Nimesh Desai, Dr. Rajesh Sagar, Dr. Prashant Mishra, Dr. Gaurav Gupta, Ms. Rajeshwari Iyer, Mr. Akileshwar Sahai, and one more person was invited, that is Mr. D.R. Sachdev. So these were the expert members under the Mental Health Care Act of Section 81. I was part of a professional who assisted this committee to formulate this guideline. Coming to this document, I would like to reflect before I start my presentation. The reflecting is when the first document or the first draft was done, it was very bulky. It consisted of 70 to 80 pages. And it required around 1.5 to 2 hours to do the assessment of capacity. Now, if suppose you have been given the responsibility of drafting this mental capacity assessment guidelines, how will you go about? You need to answer certain questions. For example, how much time should it be consuming for the assessment of mental capacity? It should be 5 minutes, 15 minutes, 30 minutes, 1 hour, 2 hours. Should it be very simple or very comprehensive? Should it be structured, semi-structured, or unstructured assessment? Should we have any clinical or professional independence of deciding capacity? Please do remember, mental capacity is a clinical construct. So that means, should we give the mental health professional the independence of deciding to some extent or not? So you need to answer this question before we go ahead. And you have to make a decision with the available resources. That means we have very limited mental health professionals. And in every OPD of the psychiatry, you will find many patients waiting. So if you are going to do a mental capacity assessment for nearly 1.5 hours, is it possible? That is the question to be answered. So with this, the committee was very clear. They said, come up with a document which should be able to used by any practitioner, even in PHC or Taluka hospital, or what you call it a subdivision hospital or Tehsil hospitals, so that Mental Health Care Act can be implemented from community health center upwards. So it was clearly said that you should have a simple document, not time consuming, maybe 5 to 10 minutes. You should be able to make the decision. And clinical independence was given some amount of stress. Now we will understand the mental capacity. So what do you mean by capacity? It is ability to do a particular thing as per Cambridge Dictionary. If you look at the mental capacity is the ability to make a particular decision at a time it needs to be done, that is basically relevant time. That means, suppose there is a question paper is given today and you answer after 3 days, it's not relevant. The relevance is as the question paper is given, you need to answer, not later. So here, mental capacity is if the assessment is done, it is at the particular relevant time. That is what is the meaning of the mental capacity. And at the same time, every person has a legal right to make their own decision. That is called as right to self-determination. It is a part of Article 21 of Right to Life and Liberty under the Constitution of India. So every person has right to make their own decision. But however, at the same time, you should also need to make a distinction between capacity and competency. Mental capacity is different. Mental competence is different. Mental capacity is a clinical construct. Mental competence is a legal construct. Capacity is a spectrum. Competence is all or none. That means competence is decided by the court. If the court says this person is incompetent, he will be stripped off by his personhood. He will never be able to enter into any legally valid contract. Whereas mental capacity is a spectrum, it is time specific, it is dynamic in nature, it is relevant to specific time. That means at this time he has taken the decision. A person is able to make decision in the morning, but he may not be able to make the same decision in the evening because of various reasons. And it is a continuous construct. At the same time, it requires a varying degree of assistance to gain the mental capacity. And it's a clinical decision. And it has both temporary and permanent mental capacity assessment, or what we call it as decision. So to summarize, capacity is a clinical construct, competence is a legal construct, and competence is decided by the court. Capacity is decided by the mental health professionals. Moving further, so what is this mental capacity? Capacity to do what? So under Mental Health Care Act, it is only for mental health care treatment decision only. I will repeat. Under Mental Health Care Act, it is only for mental health care treatment decisions like admission, discharge, treatment, and rehabilitation purpose. However, a person with mental illness may also require assistance for finance, assistance for maintaining property, mobile and immobile property, banking, shares. For this, a guardianship is required. That guardianship, both plenary and limited guardianship, is given under Right to Persons with Disability Act of 2016. That is section 12 to 14 is basically this mental capacity, and the guardianship is decided here. So please do remember, mental capacity for treatment decision is under Mental Health Care Act. Regarding financial and other matters comes under Right to Persons with Disability Act. Today, this presentation revolves only around Mental Health Care Act of 2017. It is for admission, treatment, discharge, and rehabilitation purpose. So, I would like to emphasize again, every person has right to self-determination, that is decision-making process. Now we will discuss about decision-making process. Let's have an example. This is a very concrete abstract to make you understand what is supported decision-making. Suppose, if you're going to get married against the family with your choice of marrying a girl or a man is a rights-based decision. That is your right to make your own decision, and you have chosen what you like. That is rights-based decision on one hand. On the other hand, there is proxy decision making. You do not have anything to say. Your guardians will decide. That is, your father and mother will decide you are going to marry him or her, and you can't say anything. So that is proxy decision making, or what we call it as arranged marriage. There are some marriages where parents will put some conditions, like you'll marry from our own community, the boy will be like this or the girl will be like this. And both the family and the bride or the bridegroom sit together and take a decision in the larger interest of the family. That is called a shared decision making, or you may call it as love cum arranged marriage. So, here in Mental Health Care Act, that shared decision making or supported decision making has been given emphasis. Hope you understood. Further, I would like to add some more thing. Suppose you are a doctor or maybe an engineer, highly educated. But suppose if I ask you what type of car you are going to buy, and you may think for some time. You may ask how much money I have. You may look at the bank statement. You would like to buy a petrol or a diesel car. You would like to go to showroom, you would like to discuss with your friends, you will look into the internet, you will do some test drive, you will talk to your brother, you may talk to your sister, your parents, and after 2 weeks down the line, you come to a decision. I would like to buy car X, and the color may be chosen by your wife or your sister. You being educated, degree holder, but you still required support from various people to make a decision of buying a car. A normal person requires support. Why not person with mental illness is given a support? That's the concept of supported decision making is required for person with mental illness. That principle has been ingrained into Mental Health Care Act and also to Right to Persons with Disability Act of 2016. But however, today we are discussing about Mental Health Care Act of 2017. So please do remember it is supported decision making. Next comes is this mental capacity. Does it equate to psychiatric diagnosis? No, not alone. Insight that I have illness or I don't have illness? No, it's not alone. Cognitive impairment, substance abuse, poverty, looks, education, they do not equate to mental capacity as an individual construct. But however, they do play to some extent some role. So, how do we understand this? Mental capacity means it consists of socio-cultural religious belief, psychiatric illness and psychopathology, affective component, mood. How was my mood at the time of taking decision? Is there any medical illness? Substance use, whether the person was intoxicated under the influence of drugs, any violence at the time of taking decision, cognitive function, how well he was cognitively sharp at the time of taking decision, and whether he had insight to the illness. All these construct individually make a form. That form is called as mental capacity. Individually, it doesn't make mental capacity. All these construct do play a role to make a mental capacity. Insight alone does not equate to mental capacity. Please do remember this. As a complete home, it becomes mental capacity. Individual factors do play a role. They have a complete, all these variables play important role in having person whether he had a capacity or not to decide that. Moving further, there are many mental capacity assessment tools available across the world. But however, for India, we do not have. One of the well-known capacity assessment tool is MacArthur Competency Assessment Tool for clinical research. Maybe there is for clinical purpose, brief informed consent test, quality of informed consent questionnaire, evaluation to signed consent, competency assessment interview. These are various, but it is done in Western population who are highly educated, who are basically English in nature, depending upon their cultural variables. These tools have been done. But for India, we do not have. For that purpose, this guidance document play a role in doing the assessment of guidance. And all these tools require various duration of time. MacArthur Competence Assessment Tool will take somewhere around 1 to 1.5 hours. So that do we have that much of time to do capacity assessment in our busy OPD or inpatient? Coming to the Mental Health Care Act of 2017, capacity assessment. How mental capacity assessment has been defined? So capacity assessment comes under the section 14 of the Mental Health Care Act. So what does it say? It says every person, including person with mental illness, have deemed to have capacity to make decision regarding his mental health care or treatment if such person has the ability to understand the information, that is basically comprehension, appreciation of any foreseeable consequences, that is basically risk assessment, communication of the disease, communication of the decision. So all these three play a very important role in capacity assessment. I will repeat. Mental capacity, the law says everybody is deemed to have capacity. Whoever challenges that Mr. X doesn't have has to prove that he doesn't have capacity. So for that guidance, this document comes into play. It has been defined as a person should have comprehension, that is understanding the relevant information to take a decision, appreciation of the risk involved in taking decision, for making a decision, for not making a decision, or making particular decision, and communicating the decision. All three play an important role in assessing capacity, and this is have been defined by Mental Health Care Act of 2017 under Section 4. Suppose a person with mental illness makes an inappropriate or a wrong decision. Will it amounts to loss of capacity? No. When a person makes a decision regarding his mental health care or treatment, which is pursued by others, is inappropriate or wrong, just does not say that he doesn't have capacity. It is he's been allowed to make mistake or he is allowed to make inappropriate decision also. That's what it is called as. Further, the guidance document under Section 81, as I said, an expert committee was set up. And that expert committee and a group of professional experts assisted them to form the guidance document. And under Section 81(2), who can assess capacity? The mental capacity will be assessed by every medical practitioner and mental health professionals. Now comes the question, who is mental health professional? Who is medical practitioner? Medical practitioner means allopathy, Ayush, and homeopathy. Whoever has been registered under their respective council, they are allowed to do the capacity assessment. And they need to undergo some training. Psychiatrist, psychiatric social worker, clinical psychologist, mental health nurse. At the same time, a professional having postgraduate degree in Ayurveda, especially for psychiatry, it is called as Manovignan Avam Manasa Roga, that or a postgraduate degree in homeopathy in psychiatry, or postgraduate degree in Unani for psychiatry. So these are all people have been allowed to do the capacity assessment. Now comes, we will talk about the principle of mental capacity. Whenever you are going to do the capacity assessment, you need to know about these principles. First and the foremost, you should remember is Section 14(9), presumption of capacity. The law is very clearly says that every person is deemed to have capacity. Whoever challenges it needs to prove. It's not the person with mental illness is going to prove. Person with mental illness will say that I have capacity. And if you as a mental health professional are going to do something against his wish and will, you need to prove that he did not have capacity. At the same time, Section 4(3) also says unwise decision is allowed. That means when a person with mental illness makes an unwise decision, you're not going to say he doesn't have capacity. He is allowed to make that inappropriate or unwise decision. At the same time, mental illness is not equated to capacity. The determination of person with mental illness shall not be alone implied just because he has mental illness. Mental illness, a person with mental illness also has been deemed to have capacity. So please do understand about that. And whenever we are going to use the procedure, when a person doesn't have capacity, least restrictive environment should be imposed. Please do understand. This is very important. Just because a person doesn't have mental capacity, you are not going to use very highly restrictive environment. You should discuss, document the least restrictive environment available for the person with mental illness. The last but not the least, best interest of persons with mental illness. Section 17(a) clearly says the NR should act considering the past and the present wishes and the life history, value, cultural background. The best interest principle should be taken into account by the NR to decide about the choice. So it should not be just because he doesn't have capacity, NR will take decision on his own. That is not allowed. The best interest principle prevails. Coming to what are the triggers for assessment? When do we do this mental capacity assessment? Capacity assessment is done for any person above the age of 18. What happens for below the age of 18? They are considered as minor. The family members will take a decision or the NR will take a decision. These are the situation mental capacity assessment is mandated, or what we call it as compulsory assessment has to be done. They are registration of advance directives under Section 11(2)(d). Before invoking advance directives, that means if you are going to say I'm going to follow the advance directive, Before you do that, you have to prove that that person has lost his capacity. Then only the advanced directives will play a role. Before independent admission, before supported admission under Section 89, every week under Section 89 admission, if you have admitted some person, under Section 90 before admission, and every 2 weeks once under Section 90 admission. At the same time, under Section 22, if you are going to give information to the NR, you have to assess the capacity of the persons with mental illness. If he doesn't have capacity, then only you will give the information to NR. Otherwise, you have to discuss with persons with mental illness. At the same time, for any treatment, other treatment related decision under Section 14 or for admission, this assessment is required. Coming to the documentation, you're not just doing the assessment, you have to document the assessment process. So all professionals involved in the care and treatment need to do this capacity assessment. Who did the assessment? When did the assessment take place? Where did the assessment take place? What was the decision? Why this decision was made? How the decision was arrived? All these needs to be documented before you give the professional, mental health professional gives the judgment about this person has capacity or he doesn't have capacity. The more important is when you are overruling the person that he doesn't have capacity, there the documentation should be very high. If a person has capacity, the law says the documentation can be as reasonably okay. But if you are going to say the person doesn't have capacity, you have to have a very good documentation the way I have shown here. Assessment pro forma, which is ratified by Central Mental Health Authority on 16th August 2019. This is the what we call it as the guidance document, which was signed by the CEO of Central Mental Health Authority. This is how the documentation or the document goes. Guidance document: name of the persons with mental illness, age, gender, patient ID. Suppose he has an ID in the hospital. Date of assessment, time of assessment. This is very essential because capacity assessment is time specific. Place of assessment, purpose of assessment. Is it for admission? Is it for treatment? Is it for nominated representative? Is it for advanced directives or any other purpose with related to treatment, like whether he is going to receive electroconvulsography for that purpose? If admitted to the hospital, under what section you have admitted the person under Mental Health Care Act? Whether advanced directive is present or absent? Nominated representative, if they are there, their names have to be written in a what we call it as in the hierarchy manner. Their ID and the professional diagnosis. If you have a confirmatory diagnosis, no problem, because this mental capacity assessment, the background is very essential. The person should have at least reasonable degree of understanding that he has a mental illness or his behavioral problems is secondary to arising of his brain disease. So the first point or 0 point, what we call it as obvious lack of capacity. This please do understand, from now onwards, every decision needs explanation. Without explanation, just ticking, this assessment document becomes invalid. So for every decision or every choice you are going to make, you have to give explanation. Coming to 0, that is point 0, what we call it as obvious lack of capacity. What does the guidance document talk about the obvious lack of capacity? Does he or she, that is basically a person is brought to the hospital or in the emergency ward, is in such a condition that one cannot have any kind of meaningful conversation with him or her. He's being very violent, excited, catatonic, stuporous, delirious, alcohol or substance use intoxication or severe withdrawal is there. Then you are going to say obvious lack of capacity, and you will document telling that he had this severe violence or very excited or very catatonic. You are unable to, you try to examine him and it could not be possible. Then you will immediately go to point number 4. If it is no, he doesn't have obvious lack of capacity, you will continue the assessment. If it is yes, you will jump to point number 4. Now comes the point number 1. As per the capacity assessment, understanding the information, that is comprehension, is very essential. To do this assessment, we will start with A. Assessment of comprehension by orientation method. Is the person is oriented time, place, and person? What is his answer? Whether he has, whether he doesn't have, you cannot assess. These are the points you are going to tick. And please do document what was his response. Has he or she be provided relevant information regarding his whatever the assessment? Suppose if you are going to do the admission, why you have been admitting him, what are the possible reasons, what diagnosis you are provisional suspecting him, and what are the repercussions, that information whether you are able to give. If you are able to give, fine. If you are not able to give, why you are not able to give, explanation has to be given. At the same time, whether he is able to follow simple commands like show your tongue, close your eyes, some complex task can be given. If he is able to do it or not able to do it, has to be documented. Does he or she acknowledges whether he has mental illness or not? Please do remember, under this point number 1, we are asking 4 questions, but we are not deciding here. It is basically collecting the information regarding comprehension. Although A says that he does not have orientation to time, place, person, it can be clearly said that he is delirious. But still, a person with mania may have this delirious state, or maybe a person with withdrawal symptoms may have this delirious state, but still, no importance. That means complete decision kind of has been not placed under the comprehension. You are going to take this information and move towards the point number 2. Please do remember, the point number 1 do not have any shortcuts, or jumping to the next section does not have. Here you are going to collect the information, document the information. But now comes very important. That is appreciation of risk. That is basically whether he is able to weigh the risk is the question. Does the person or the individual agree to receive treatment suggested by the treating team? If it is yes, you will immediately go to 2B. If, and then you will ask him why he or she has agreed for the treatment, and you are going to document. Suppose if he does not agree for the treatment, you will immediately go to 2C. Again, you are going to jump here. So you are not going to 2B, 2C. If it is no, that means does he or she explains why he does not agree to receive treatment? That you are going to document here. That's very essential. So the point number 2B or 2C is decided based on the A, 2A. So here it's again the decision of deciding jumping to 4 is not allowed. So you have taken information from the point number 1, point number 2. Now depending upon this, you are going to point number 3, that is communicating the decision. If the individual is able to communicate his or her decision by means of speech, right, expression, or gesture, or any other means, that you are going to document. Yes, he is able to convey the message, or he is unable to convey the message. He is very incomprehensible. He is unable to communicate at all. Or is there a language barrier? That you are going to document here. Based on all these 0, 1, 2, 3, you are going to 4. That is basically now based on the assessment 0, directly we will go to 4. Based if he doesn't have, if his obvious lack of capacity is seen. For 1 and 2 and 3, you are going to collect the information. Now you are going to decide based upon your clinical picture. Based on the above interview, relevant history, behavioral observation, clinical findings, mental status examination, findings noted in the medical records, you are going to take a decision. Yes, this person has capacity to take decision, or capacity for treatment decision is there. Or else you're going to take a decision, no, he doesn't have the capacity, he needs high support from the NR. So these are the 2 choices you are going to make. Suppose if you are going to make a 4A telling that he has a capacity, then you are going to document his name and you are going to sign yourself, and the person with mental illness, since he has capacity, he will sign under 4A and he has capacity and he will make a decision. No, if you are going for 4B, that means he doesn't have capacity. Then you're going to say, I, Mr. So-and-so, the nominated representative of that person, that is the person who has been evaluated, agree to make decision on his behalf. That is, signature of the NR will prevail now here. That is, signature and name of the NR will hold good. to help you in the assessment, there are some anchoring questions have been given for you. The anchoring question for comprehension, how to do that? It's very simple. Talk to the person with mental illness. Introduce yourself. Reason for the current interview. Please tell him about yourself. That's very essential. Without just going there and just start interrogating him is not appropriate. You have to say, suppose if I'm going to do the interview, I'll be telling that I am so and so. I'm Dr. Suresh, professor of psychiatry. I've been doing this. I have come for assessment of mental capacity and I've been working here for so many years. At the same time, start asking about his demographic details. Ask his name, age, gender, from where he is coming, what is his education, how was his work, since when he is working, does he enjoy about doing work, whether he is married, unmarried, what is the marital status. Those are the questions general discussion starts moving in. You can ask some of the personal questions and word related questions. If person B is highly paranoid, he does not answer his personal questions, ask about the current affairs around the world. What happened yesterday? How is this world is moving now? What happened yesterday in Delhi? What was the decision? What was the cricket match recently happened? So those are the questions you are going to spend time. Around 4 or 5 minutes you will discuss about this. Now you will move to, then you can directly move into what do you believe is wrong in your health? What treatment was suggested or recommended by your doctor? Are you satisfied with the information given to you to make decision? On this basis, you are going to take certain decision about comprehension. Now comes the appreciation of the risk or risk assessment. Now you are going to ask, do you believe that you need some kind of treatment? Do you believe whether the recommended treatment might be the potential benefit? Or else, do you believe whether the recommended treatment might be a potential risk? What do you believe will happen if you are treated? What do you believe will happen if you are not treated? How do you decide to accept or reject the treatment, recommended treatment? What makes your chosen option better than the suggested treatment option? So on that basis, these questions will be asked, and then you're going to make a decision. Yes, he has the appreciation of risk, or he doesn't have the appreciation of risk, or weighing the risk he has or not. Communication is very clearly, have you decided whether to follow the doctor's recommendation or not? Why? And can you tell me the treatment decision whether you're accepting or not? And that you are going to take the decision on. To conclude, Mental Health Care Act revolves around the rights of persons with mental illness. Even in the preamble, it has been clearly documented. That means this Mental Health Care Act basically talks about rights of a persons with mental illness for providing services and to protect their rights during the provision of these services. At the same time, liberty of a person with mental illness is paramount. Please do assess capacity before you are going to take any decision against his wish and will. This is very essential. That is the reason Section 81 of the Mental Health Care Act plays a very important role of mental capacity assessment. At the same time, document the assessment of mental capacity. Because if you do something against his wish and will, you have to prove it is not the person with mental illness. Because the law is, by default, says every person, including person with mental illness, has capacity. Friends, if you like this video, please do subscribe my channel youtube.com/C Suresh Padatmat. There are many similar videos, educational videos available. Please do subscribe, click the bell icon, share these videos. Thank you very much.